I just want to, we're going to talk a little bit. I know we're moving fast, and we only have a week, and I know that was your first crack at closing, and hopefully you got some big picture takeaways by getting up on your feet once more. Hopefully, you heard some things, and in a workshop you got to either work on some things or hear some more specific critique. That's what those workshops are for, right? Even if it's not applying directly to you, if one of us on the faculty is talking to someone else in your small group about something they do, listen carefully, because odds are, being that you're all at the same place in your training, odds are most of it applies to you too. And if it's something you're like, well, that doesn't, I speak loud enough, they're telling her to speak up. Well, be patient, because I guarantee the next one does apply to you, right? Here's something though, this happened in my room, so I don't think that it's unique to my room. I'm sure it was happening in here, right? So I'm going to give a lecture about cross-examination, right? This is the cross-examination block. This is the most fun that we could possibly have. This is one of those that, like, I look forward to cross-examination, maybe because I'm a prosecutor, I don't get to do it that much. But I love teaching cross-examination. I love talking about cross-examination. This is one of those where, like, all right, I can listen to a lecture about cross-examination. Imagine if I take this block, and I only got a half an hour. I got to tell you, I produced a lot of blocks, and I had to squish things in. It killed me to squish cross-examination, one of my favorite topics, into a half an hour and have you up doing it this afternoon. It killed me. I'd rather have it be an hour every day of the week. Just couldn't have it. Imagine if I took this very valuable time, this half hour, when I have you, it's something I need to give you, I want to give you, something that is important to you, that could be cool for you to learn, that you want to hear, and it went like this. On the book that I signed earlier this week, page 149, it has a section that's called Why Cross-Examine a Witness. Your goals during cross-examination are to control the witness, establish facts to build a theme and theory, and establish facts that build up the credibility of your witness and diminish the credibility of your opponent's witness in addition to the witness being cross-examined. In order to accomplish this, you must know that the witness does and only accomplish the thorough, complete, and continuing case analysis. When preparing specifically to cross-examine, your first step is to identify the legal issues in your case that work for your case and your theme and theory. Right? It does not work. There's no way you can possibly ever in the universe present by having anything akin to that looks like reading, ever. Right? You cannot have this document that is, all of a sudden become your crutch. The random scratchings that you made last night or what you banged out on your little laptops last night that has now formed the basis to be your crutch in your closing argument. If you put it here, right, it has to be something that you go to, that you're away from while you present, and that if you hit that all-important, memory block, and you need the trigger to get going on your next thought, that you go visit. Take the time, go back to your spot that's away from those notes, and then launch again into your next thought and talk to people, and look at people, and talk to them about that which you know, that which you prepared, and that which you feel very strongly about getting to them. It can't be reading. Because as you know, right, can anyone right now name the 3 things that I just read out about why you cross-examine a witness from this book? No, because you blanked on them. All you were doing was looking and giggling at the fact that I'm up, I own this time, I own a half an hour, I'm presenting something to you, and I'm using that valuable time on this valuable topic to read. And you know what? Sure, I may have hit the 3 points, like Bill's lecture yesterday, I may have hit the 3 points as if it's an essay, but it doesn't count, because you didn't hear any of them because I read it. I'd rather get up here, not having looked at page 149 for years, take my best shot at just talking to you about what those 3 things are, and if I get one of them, I do better. And you know what? You hear more of it. So we need to, so we're going to do this a lot quicker than I would imagine. We need to get in a place where the notes are not yours. We need to get in a place where if they're in the courtroom at all, they are way, way, way away from you.